Welcome to your roadmap for the A7 Family Law and Practice module. Today, we are focusing on the essential rules and procedures you need to confidently handle no-fault divorce and dissolution cases. Before drafting, verify the timeline. Under Section 3 of the Matrimonial Causes Act and Section 41 of the Civil Partnership Act, there's an absolute bar on initiating divorce within the first year. Post-2020 Act, you no longer prove adultery. The only ground is irretrievable breakdown. Because the court no longer requires evidence of blame, your focus as a practitioner shifts to strict adherence to procedural timelines. Success depends on administrative accuracy rather than building an adversarial case against the other spouse. This move toward a less adversarial system means couples now have a choice when applying. The 2020 Act introduced the ability to file a joint application where both parties agree, alongside the traditional sole application route. When you are ready to formally begin, the standard method for legal professionals is to use the HMCTS online digital portal. To submit a valid application, prepare the matrimonial order application, Form D8, along with the marriage certificate and the court fee. You must also include a statement of reconciliation under Family Procedure Rules Part 7, confirming you discussed reconciliation with your client. Submitting these documents is the moment the court formally issues the application and takes jurisdiction, starting the official statutory clocks that dictate the rest of your timeline. The first timeline you must track is a minimum wait period of 20 weeks. This clock starts ticking from the moment the application is issued, and you cannot apply for a conditional order until it finishes. This 20-week window is a cooling-off stage, giving the parties time to reflect. Even if both of the parties agree they want to finalize everything immediately, you cannot speed up this clock. Once those 20 weeks expire, you can apply for the conditional order. The court will review your application, verify proper service, and officially pronounce the conditional order. Pronouncing the conditional order is a major legal milestone, but you need to be very clear with your client at this stage. They remain legally married or in a civil partnership until the court grants the final order. The final timeline begins once the conditional order is pronounced. You must wait 6 weeks and 1 day to apply for the final order. A rare exception to dispute this is if a respondent faces grave financial hardship, which must be settled first. Provided there are no objections, the court will pronounce the final order. This is the absolute legal conclusion of the case, officially severing the marital or civil partnership ties. Looking back at the learning outcomes for this module, your objective is to identify these relevant facts, advise correctly on procedural matters, and draft accurate documents like the D8 application. Strict adherence to the 20-week reflection period and the subsequent wait for the final order is essential. Tracking these timelines ensures you maintain professional conduct while properly managing your client's expectations. Mastering this step-by-step roadmap gives you the tools you need to guide clients through a relationship breakdown with the exact procedural precision required in modern family law practice.